Next from Springfield, we sit down with the Chief Justice of the Illinois Supreme Court, Rita Garman, as her term as Chief Justice is winding down. We talk to her about her term as Chief Justice, as well as whether the Illinois court system is properly funded, how recent technology is bringing new challenges to legal rulings, and how the law has changed since she first became a judge in the 1970s. This runs about 50 minutes.
Chief Justice Rita Garman, thanks for joining us again on the Illinois Channel.
My pleasure.
It's been 3 years, hard to believe, but 3 years ago that you were inaugurated as the Chief Justice. I'll remind the audience that unlike the U.S. Supreme Court, justices on the Chief Justices on the Illinois Supreme Court have a limited term of 3 years.
They do. They do.
As we near the end of your completion, I believe it changes sometime in October.
The last day of my term is October 25th.
Let's review a little bit of some of what happened when you were inaugurated. You said you wanted to add clarity and competence, clarity, and cooperation would be what you would hope you would leave as your legacy.
Yes.
As you now come to the conclusion of your term as Chief Justice, have you achieved those goals?
Well, I think I have in part. It's an ongoing process, but transparency of the courts is a very important issue to me, and also having our courts operate with greater efficiency is also important. Obviously, due process is critical, and we have to operate effectively, but we need to operate efficiently too. The frequent criticism of the court system is that it takes too long and it costs too much, and so we need to address both aspects of that equation.
Yeah, in fact, you had mentioned that you wanted to speed up the decision-making process, and I know in some previous terms before you becoming chief, there were some cases that it seemed like it took 18 months in certain cases to get a judgment.
Yes.
Have you been able to expedite the decision-making process, and if so, how did you achieve that?
Well, the Supreme Court is very current on their case filings, and when the case is completed, in other words, when the briefing schedule is completed, they're put on the very next call for oral argument. So we're right up to date with what's happening. We're not holding any cases back, and we try very hard to meet our self-imposed deadline, which is if we hear an argument, for example, we're in September now, we've heard some arguments already, we'll hear more next week, we'll have a draft opinion ready by the November term of court. So that we'll try to keep it as timely as we possibly can. Obviously, we have to be very careful, very thorough, and complete in our analysis so that the parties know and the people know that we've done our due diligence in making the decision.
As Chief Justice, you're the head of the judicial branch during your term.
Yes.
To what extent can you carry your agenda downstream, so to speak, to the lower courts and to see that they are expediting their decisions and following the agenda that you're trying to set?
Well, one of the initiatives that we're trying to pursue is to develop a better measures of judicial performance. In other words, get a better idea of how efficiently we're handling cases, how long those cases are taking, keeping the metrics the same from one area of the state, one county to the next county. Not to play counties off against each other, but to assure that everyone is moving cases along in a deliberate fashion. So we've been working on performance standards and attempting to develop those standards that will be fair and also understandable.
And one of the things that you were trying to do is also update the technology relative to the judicial branch and the operation of the courts.
Yes.
Have you achieved the goals? Or?
Well, again, that's a work in progress, but the court is now about to go live with a new case management system called C-Track, and that will much more effectively and efficiently handle the cases that are processed through the Supreme Court and do it electronically. And then that, of course, then moves to the appellate court, and then the court has mandated that our circuit courts, as well as our appellate courts, come into the electronic age. and we've set dates certain in the appellate court by July 1st of 2017, and in all the circuit courts by January 1st of 2018. That's a pretty tight schedule. We're working very hard to meet that schedule, but we need to have our courts be in the electronic age so that we're handling cases by electronic filing, and so the people can track those cases, and you don't have to go from one county to the next to find a case. You'll be able to sit in your office and look that information up. We think that will be very beneficial to the parties and to the lawyers and to the public. And the public, of course, will be able to be a part of that too.
I will just say that about 20 years ago or so, 18 years ago, I had a reason to have to go down to the Sangamon County Courthouse. And here I had to take off from work, drive down to the courthouse so a clerk could hand me a piece of paper.
That's right.
And I thought, couldn't you have had a PDF that I could just print it out?
Exactly.
So it really makes a difference for not just those who work all the time within the court, but for the public.
It does, because if you, under the current system, if you want to file something, we'll say in Sangamon County or in Macoupin County or Scott County, you'd have to drive there and present your papers to the clerk, get them file stamped, pay whatever fee is necessary, and then maybe you have dealings in several different counties. And you'd have to do that all before 4:30 when the clerk's office closes. In the electronic age, you can do that from your office, and it's handled, you can be filing up till midnight of that day, and it still would be effective as of that date of filing.
As we sit here, I should say, and here we are taping, the Illinois Channel has taped for quite a number of years. I think the first thing we ever taped was in December of 2002, here in the chamber of the Illinois Supreme Court, when you were hearing a case on redistricting.
Yes.
For the census that I guess was of 2000. It was a challenge to redistricting at that time. You now have installed cameras so that you put the video of your cases up on your website where people can see it. And we, the Illinois Channel, don't always have to bring our own cameras into the courtroom anymore.
Exactly. And I'm hopeful that before very long we'll be doing it live so that it won't be delayed. We've also, adopted an extended media coverage program for our trial courts throughout Illinois. And we started that as a pilot project, and it really has grown and become very effective throughout the state. And so the court, during my term as Chief Justice, in the spring of the year, we took the pilot status off and made it a permanent program of the court. It's still in the discretion of the circuit and the chief judge and the trial judge as to whether there will be cameras used in the courtroom, but it can be available, and where we have it, we found it works very well.
I will tell the audience one of the times when we were taping early on, and again this probably goes back about 12 years ago, we had a law firm call us and we played audio back over the telephone so that this law firm could hear what the testimony was in the court. So again, it wasn't that long ago that the delay in just getting access to what was being said really caused a lot of consternation within the legal system at large.
Sure. Well, we think it's a good thing moving forward that, first of all, cameras have become far less intrusive. They're not the big items that we used to see that were so obvious. In most cases, most people don't even notice that there's a camera present and that the camera's running. We have pretty strict rules on how they're utilized and where they're utilized. But the parties and the people that are involved seem to go about doing their work without much acknowledgement of it. And further, I think it's a good thing for the public to see how courts really operate and see our judges at work. Our judges are hardworking people, and they take their obligations very seriously. And where you have this opportunity to observe, I think it works to improve confidence in our court system.
Let me combine a couple of things we just touched on. One was, as I said, the first thing we ever looked at or taped here in the courtroom was that challenge to the redistricting after the 2000 census.
Correct.
Now, recently, there was this whole ballot initiative to have redistricting taken away from the political parties. I know you don't talk about cases going forward, but this one, you just had a decision on it.
Well, it's still in the rehearing. There's still a rehearing that is not totally completed.
Okay, I didn't know if you could comment on
I can't comment on it other than to tell you that we processed that as expeditiously as we possibly could, because we were very well aware that there were time constraints, that the court had to make a decision to move the process forward.
That being said, how does a rehearing happen? I mean, does that mean that a different decision could ultimately be handed down?
That's the question, of whether the court would actually rehear the case, reconsider it. The court has entered an order denying the rehearing, but there are other writings that are going to follow.
I see. Also different than the U.S. Supreme Court, we have judges, as we've talked in the past, judges here run for office. There's always the question that people worry about, I mean, in their minds. Are we getting the law as the law, or the law as someone from a political party wants to apply the law? Is it much of a concern to you or the other justices how the rulings of the court are viewed, and whether the public, perceives a political taint to any of these decisions?
Well, it's important that the court makes decisions that are fair and impartial. It's really our task and our responsibility to provide a level playing field and to allow both parties to present their cases and then make a decision. We don't hold focus groups to see whether the decision will be popular or anything like that. It's based upon the law and the evidence. And, whether it's a jury trial at the trial court level or a case on appeal, it's informed by the facts and the law of that particular case. And oftentimes, on our Supreme Court, not all the decisions are unanimous. You wouldn't expect them to be unanimous. There are 7 people that come from different areas of the state, different experiences, and have different views about the law and what it says. And so I think that kind of debate and discussion and discourse is really a healthy process to the ultimate decision making.
To what extent do you or the other justices go out and talk to the public and try to, for lack of a better word, just open up the process so that people have confidence? Ultimately, hopefully we have the public be confident in the workings of government, whether it's the legislative branch or the judicial branch or the executive. To what extent are you all sensitive to that, to make the court proceedings to where people maintain a credibility in how it operates?
Well, we're quite sensitive to that. The court encourages our judges to go out and talk to community groups and to be active in community affairs so that they will know what's going on in their community. As to the Supreme Court, since I've been on the court and since I've been the Chief Justice, we've taken our court on the road in 2 specific occasions. We went to Ottawa and held court there in the appellate courthouse, which in past years served as this home of the Supreme Court at one time. And then in May of this year, we went up to the 2nd District and went to Benedictine University and held oral arguments there in their auditorium. That instance, we had over 500 people that came to view the proceedings of the court, heard oral arguments. A number of them were students from nearby high schools and colleges, and we had made the briefs available to these young people and these students so that they know what the case was all about. Then after the case was over, the attorneys that were involved in the case had an open forum and talked to them and answered questions about what they were doing, the procedure that was involved, and the case that was involved. We had wonderful press coverage for that. We think it was a really good thing to do to help with transparency and to see how the Supreme Court works. this is a beautiful courtroom that we're sitting in today, but frankly, not many people come to observe what happens with the court. So we felt, and I felt, it was important that we go out and meet the people where they are. Another thing we did in the last 2 years, we had an evening session at court in March when the legislature was here, and we invited the governor and the legislators to come over and to observe oral arguments of the court in a case. And we found that to be very beneficial, and we really got very positive feedback from the legislative branch and from the governor. They enjoyed being here, they enjoyed watching the proceedings, and I think it gave them a great perspective on how the court deals with questions on legislation, legislative interpretation, challenges to constitutionality of statutes. They had the chance to observe firsthand, first of all, the two of the public agencies in action, the Attorney General's office and the Office of the State Appellate Defender, and they had an opportunity to hear both sides, the challenge and why they thought that there was a problem with the statute or why it was unclear. And we found that our legislative colleagues, it was a kind of an eye-opening experience for them to see that, oh, my goodness, people pay attention to what we do, that we read the legislative debates when it's not clear. Some of them weren't aware that we did that, and we do.
Well, and that was one of the questions, how do you determine legislative intent?
Right.
When you have a case that comes before, and in most of the cases, a lot of the cases are going to be important to the parties, but not necessarily important to the people at large, one might say. But when you have a high-profile case, does it impact the court, the justices? Do they feel a little more pressure or awareness, or?
I don't think so. We're concerned with the law. We're not concerned with the drama of the surrounding circumstances. We know the stakes are big in these cases by the cases that come to us. We know that there are people's lives and livelihoods that are involved in these cases, and so we're very careful with the consideration of the cases. And I think that the public should be assured that we give careful consideration.
This may be an indelicate question, but when you look at a law being challenged that was written by the legislature, and I'm not thinking of any one particular law, but just in general, do you think to yourself, if these guys would have written this thing better? I recently interviewed actually a presidential candidate, Gary Johnson, who was a two-term governor, and he said about half the laws that we pass are fixing imperfections in the laws that were passed previously. Do you have any thoughts on that? I mean, is there something that the legislature might do so that the actual intent is clearer, or should there be some process change? Well,
we appreciate it if we have a very clear statement of legislative intent, why they're passing this particular piece of legislation and what they intend to accomplish. I would say they think it's clear when they pass it. They don't think there's any question about it, because they know what they want to do, and it seems like they're doing it. But when it goes out, you find out where the questions are, and as it operates, how does this really operate? What does this really mean? Is it abundantly clear? And oftentimes it's not. And it's not that it's an intentional act. They don't intend to make it obscure. But oftentimes we don't know, because we start out with a presumption. First of all, there's a presumption of constitutionality of statutes. And second of all, we look at the legislation and we look for plain meaning. If the meaning's clear, then it says what it says. And we can't weigh in on whether we like what it says or whether we think that was silly to make some provision like that. It says what it says, and so the legislature has spoken, and we honor that. If it's not clear, if it's ambiguous, if it's subject to at least two reasonable arguments about what it means, then we have to resort to looking to the legislative debates and looking to, we try to reconcile the statute as a whole. In other words, we assume and presume they didn't mean to have an absurd result, they didn't mean to set something up that was internally inconsistent, that it needs to read as a continuous and cohesive whole. So we factor all of that into coming up with a conclusion. Now, we come up with a decision and we say what we think it means, what we believe it means from our study. Then, if the legislature says, well, the court got that wrong, that's not what we meant or that's not what we intended to do, then the process is they should go back and fix it. And oftentimes, if we find that there's a hole in the legislature, there's something that they needed to address but didn't for one reason or another, we will point that out in the court's opinion, that we urge the legislature to re-examine this or to address this particular concern.
And sometimes the law you're looking at isn't from the legislature per se, it's going back to the 1970 Constitution. It's what was meant by something. You've had a couple of decisions on that recently. On one hand, again, just the Hooker decision was going back and looking at some of the Constitution. Also, some of the pension decisions that you had to rule on recently. You're going back to what was the original intent.
That's right.
What would you say to the people that go, well, how can you have 7 people and they're all informed people on the law, they're on the Supreme Court, they don't get any higher in Illinois than that, and yet if they're reading the Constitution differently, then what do we go by?
Well, you go by what the majority of the court means. That's why, there's 7 members of the court, so there has to be 4 that agree on a certain interpretation in order to have it be an order of the court. Now, you get dissents that say they're not right, or they misinterpreted that, or they didn't consider something else. But nonetheless, if it's a decision of 4 members of the court say it, it is an order and it is the law of Illinois.
When you have a dissent, is that judicial venting, or is there an actual purpose for the dissent?
There's a purpose for it. The purpose is to set forth the analysis of why you believe the majority is incorrect, and what if you think they have not looked at some aspect that they needed to look at, or they've misinterpreted a case, or they didn't look at another provision. That's an opportunity to say, I don't agree, and here's why.
Can I go back? And I realize I want to be delicate here because I don't want to put you on the spot. On the Hooker decision, this was the redistricting. You had a 4-3 decision. I think a lot of people, they're not going to take the time to read the decision. Can you, unless you don't want to do it, and you can tell me you don't want to do it, can you summarize why was that unconstitutional? What did the court say, the majority say as to why that was? Was that?
It was based upon that it provided for additional duties for the Auditor General, and that was he was not included in Article 4, which is the legislative article of the Constitution.
So the majority said you can't, through a citizens' initiative, change the duties of the Auditor General, which is a constitutional office.
That would be
their argument.
Ultimate outcome.
Okay. As we take on different cases here, and you all, well, let's say you go back and you have a big decision like that, or any of the other, the pension decisions, whatever. I was struck in looking at the videos 3 years ago when you were being sworn in of how well everyone gets together, and you always seem to be very, cordial to each other.
Yes.
do you get into heated arguments behind the scenes? What happens behind the scenes?
Oh,
it's like,
yes.
Bill, you're wrong. Or something.
Well, we do get into heated discussions, and sometimes they're quite protracted, and and issues are pretty vociferously argued, as they should be, because there needs to be a real testing of the waters and a testing of theories and analysis and cases and that sort of thing. But it never is personal. It never is, you're wrong and you're ugly. It's, or, I never did like you, or anything like that. Our court we are 7 different individuals, but we all are very respectful of each other on a personal basis. And so while our discussions can be very frank and very, as I say, protracted and passionately, right? And people feel very passionately about their position, at the end of the day, the decision's made, and we move on, and it's not personal. It's just not personal.
In the course of those discussions, have you, and how long have you been on the court now?
I've been on the court 15 years.
15 years. Have you seen some of the justices over the 15 years, relative to the arguments behind the scenes, change their positions based upon those arguments?
Yes, I have seen that. I have seen people re-examine their position and maybe move to a different position in a case, and that's as it should be, because that should be the value of discussing it and exploring it, and it doesn't happen every time by any manner of means, but it does occur. And I tell people that if every decision of the Supreme Court was a 7-0 decision, they should be concerned, because that would mean that either people aren't paying much attention, or kind of anything goes. And in fact, when we have a 7-0 decision, I will tell you that it really means that everybody's looked at this from different angles, and when the court says that's the way the law is, and this is the decision of the court, it's a very strong opinion. But that doesn't mean that the cases that get dissents are not considered as strong as carefully as that. So it's just a case-by-case analysis.
Is it harder, or is it any different when you're looking at when you're going back to the 1970 Constitution, as compared to the examination of a challenge of a law that was passed 5 years ago out of the legislature? Does that make a difference?
No, it doesn't. Not in the level of difficulty. The analysis is very careful and very legalistic.
And it strikes me when we talked about technology before in the courtroom, but there's just technology in general. And so technology will raise new constitutional questions that we never had before.
Oh, it certainly will.
How does one,
will.
I was struck some years ago, and I don't remember this, I don't even believe it was in Illinois, but someone was using a camera to take pictures of women's skirts.
Sure.
And they weren't prosecuted because there was no specific law against that. Well, you never had that technology before.
Right.
So technology will then all of a sudden create a whole new challenge to the law on privacy rights, on any number of things.
Exactly.
How do you, and let's take drones. I'm sitting here thinking they'll go, oh, isn't this great? We can deliver burritos. Now, it's like, I don't know that I want to have that humming all over my house.
Right.
How much of my airspace do I get to control over my house? Do I have any privacy rights? I mean, these are the things that I'm thinking about as we're about to have our neighborhoods inundated with drones flying.
Certainly.
How do you, as a justice, or as the court system, not to make it about you individually, take something like brand new technology and then still apply it to something, the law of the land, which was written in 1970?
Well, obviously we have to keep up on the newest developments, and there are areas of the law that have developed that were unknown when I first became a lawyer, for example, and even when I first became a judge. Cyber crimes and that sort of thing, and the court has recognized a tort of what's called intrusion upon the seclusion which is a common law recognition by the Supreme Court, and it's exactly to address the situation you were referencing earlier, where someone surreptitiously takes photographs of someone in a dressing room, or someone can hack someone's email account, or you know, we've had instances where people use technology wrongly to attain some illegal purpose. So you know, we have to keep up on kind of what's happening, but the cases come along, and then we have to see how that fits in with current law, and maybe certain changes are necessary.
How challenging is that? I mean, I could, you know, as we sit here, we're having this whole number of emails. There is more being released today from former Secretary of State Colin Powell. And in a different context, someone's emails might be released. Let's say it has something to do with a criminal activity. Then the question would be, can you use that evidence, or was that in violation because you didn't get that through a warrant and through the constitutional protections?
And we see that in many different applications throughout the cases that we deal with. In the civil area, for example, when you have civil litigation, and we'll say between two business groups or a private citizen against a business, and they want to see emails, there can be thousands of emails that are that might or could be relevant. How do you draw the, how do you draw the parameters? How do you do what's reasonable to allow the one party to discover what they need to without being overly burdensome on the other? But technology has provided us with many positive steps forward. For example, the justices of the court now have iPads, and that is, number one, we can put all of the briefs and our opinions and everything on the iPad and carry it like a little book. So when I first started on the court, since I'm from Danville and the court's in Springfield and I'm in Chicago a lot, and Quincy and Bloomington, I'd be taking things with me to read, and I'd have to kind of guess, well, golly, am I going to get through 3 sets of briefs? And then they were in the back seat of my car, and
how much to carry along?
How much to carry along? And heavy briefcases. I carry an iPad now, and I have that accessible. We can be sitting on the bench, and someone quotes a statute, and we can look that statute up and see it right in front of us. We don't have to.
I'm kind of laughing because I know in previous cases, and I think going back to when Justice McMurrow was on the bench, but they would come out and stack evidence.
Yes.
And we could barely see the justices. They're all hidden behind about 8 inches, 10 inches of paperwork.
Well, I can tell you that over the years in my office, for example, the library has shrunk dramatically because my clerks are all trained on technology, and it's all done on computer. Legal research today is done by the computer, not by pulling the volumes of the book. The court doesn't even publish opinions anymore other than online.
You know, I think one of the things, you tell me if I'm quoting wrong, or just that one of your concerns also is just the accessibility to justice, that you don't want to have the cost of justice become so prohibitive.
That's
and
right.
we see that not only for the average person on the street who has to interact with the court system, but we often hear it in regards to tort law, that people will be suing something, and just the economic burden of defending yourself if you're a business or if you're an individual. Technology has brought down the cost of doing business in any number of other fields. Is it having an impact, or is there any way to get the cost of litigation down in the court system? Well,
as far as saving you paper, if you have to put together all this paper to file, yes, you don't have to do that anymore. You don't have to download all the things in paper form that you needed to before. We're certainly very aware of the costs of the filing fees that are involved with the court system, and certainly working on streamlining that to see what can be done to make it more efficient. The court has started an Access to Justice Commission a few years ago. When I became the chief, I thought we should integrate that into the court's administrative structure so that we look at access to justice issues on an ongoing basis. And so we did that. And the Access to Justice Commission has come up with some wonderful suggestions. For example, standardized forms that in simple kinds of cases that self-represented litigants can fill out. But these forms are acceptable statewide in our courts, and it's basically a fill-in-the-blank kind of thing, so that they can do that with relative ease. We've done certification of language access people, so that it's surprising how we're a very mobile society today, and many of our courts encounter people that speak many, many different languages. So we are, trying to make sure that when the courts deal with people that don't speak English, that we can speak to them in their native tongue.
There's a couple of things I wanted to. Civil justice, there was a case or press conference the Illinois Channel aired just recently calling for tort reform. Mm-hmm. Now that's been debated many years and will probably continue to be debated for many years. One of the allegations that those who were calling for tort reform was on the issue of venue shopping. I don't know. Does the Illinois, do you as a Supreme Court, do you get involved in any of these issues?
Well, we have. They're forum, what they call forum nonconvenience motions that we see on occasion, where they either are filed in the circuit court that this case should be moved from this county to a different county, and sometimes, and then that goes to the appellate court, and then it can't even come to the Supreme Court. So we've had some cases in that regard.
Also, a continuing issue, I think, is the cost, not necessarily to those bringing cases to the court, but just financing the judicial branch.
Yes.
Everyone knows Illinois has had a horrific situation with the budget, and even before that, Justice Kilbride, who was your predecessor, was talking about how little the judicial branch got out of the funding from the rest of the other branches. How would you assess the funding of the Illinois court system? Is it adequate, terribly inadequate? I don't want to put words in your mouth. Just tell me, are we okay, or how would you assess it?
Well, the court's entire budget is less than 1% of the state's budget. So it's really infinitesimal in compared to all of the other expenses and income that the state of Illinois has. Doesn't mean that we're any less important. We are the third branch of government. There are three major components of the court's budget. The first are judicial salaries, judges and salaries. Now, the legislature sets the number of judges. And of course,
Do they consult you or on something?
Sometimes, but often not. And then they
Is that the blind leading? I shouldn't ask it that way, but it would seem to me, how would the legislature know how many judges the judicial branch needs?
Well, they hear from local constituents and may decide to add judges in a certain area of the state. But so we're dealt with a certain number of judges, and then of course the legislature set the compensation. So you multiply that out, we have to pay that. The second part of the budget is really for administrative expenses, and that would be our administrative staff and taking care of this building, for example. We have appellate court buildings throughout in the 5 districts of Illinois. So, heat and light and all that sort of thing, upkeep on our buildings. And then the third very important part of our budget is the money that goes through to probation services. Now, the legislature has never fully funded the probation services from the time they set it up in 1977. And we are constantly asking them to fully fund these local services, because we know that we can be most effective when we take care of our people at our local level.
Is that for probation officers?
That's for probation officers and probation services programs.
When one of Governor Rauner's major goals is to reduce the prison population by 25% over a 10-year period, and he's worked, I think, across the aisle. He just recently signed 5 bills that were having to do with criminal justice reform. Some of them are relatively minor, it seems like, but important to prisoners. How much is they're charged for phone calls and things. Are you involved in that? Has the governor approached you and said, from your standpoint, what should we be looking at to reform?
Well, the governor has set up a task force to look at that overall issue, and of course we're vitally concerned with that issue and making sure that that the people that are in our correction system belong there and are appropriate for being there, and that we're doing the best job that we can do. We don't sit on that commission, but our administrative director is ex officio, so we do to have that input. And there are 2 former judges who are retired, former chief judges, Judge Robb and Judge Sawyer, that serve on the governor's commission, so on sentencing reform. So they have brought an important input to that process from the perspective of the judiciary. We really couldn't do that. No sitting judge can do that because their ultimate goal is to propose legislation. And of course, if legislation passes, guess who's going to have to decide if that's constitutional? So that would be a conflict for us to sit and suggest they pass something and then turn around and decide whether it's constitutional or not.
Last December of 2015, there was created the what's called the problem-solving courts.
Yes.
What is that, and why were those set up?
Well, we established standards for our problem-solving courts statewide, so that they would all operate under the same basic parameters. Problem-solving courts are like drug courts, mental health courts, veterans courts, domestic violence courts. These are specialty courts that deal with a defined population of individuals and really try to apply a therapeutic model to that particular problem or issue. We know that our jails and our penitentiaries have a lot of people in there that have mental illness issues. There's a frustration, really, that if you talk to sheriffs and to local law enforcement about people that commit offenses because they have mental issues, and they go in, they're taken into the jail, they come through they're processed through the courts, they may do some time, they may be on probation, they come back out, because if you don't address the problem, they're going to be right back in the same circumstances. So, it becomes a cycle. And so in an attempt to break the cycle, to get people off drugs, for example, and to have them make something of their lives, these problem-solving courts have been very effective in helping certain offenders.
Is it a way of saying, look, instead of us just going through the standard procedure where we're going to prosecute you and jail you or whatever, we're going to try to say, maybe by working with you in a different context, we can avoid the cost of incarceration, which is really high, and all the hardship it creates for you and everyone else.
That's right, and can help people to be more productive citizens and not to be in this cycle, because there's costs at all levels. The human cost, of course, is significant.
You are now the longest serving, I believe, female judge in the history of Illinois, right?
I don't know in the history of Illinois, probably, because there weren't very many women judges.
Many. We've talked before, back when you started your career, there weren't many women in the law at all.
No, there were 8 women statewide when I became a judge in 1974. And so I know I'm the longest serving woman judge, second longest serving judge in Illinois at this point.
And you were only the second woman to be on the Illinois Supreme Court.
That's correct.
And now, as we sit here in the chamber, of 7 judges, 3 are women.
That's right. That's right.
Has that had an impact? I mean, we look at the change of law, not only during your time for 3 years, but going back to when you became a judge in '74. How has the law changed? And as I once asked Marianne McMurrow, if the law is the law, what difference does it make if you're a woman? Can you just kind of reflect on some of the changes that you've seen in that regard?
Well, I don't know that it's because women have become lawyers and judges, but I think in the last 40 years we've seen significant changes in the law. For example, in the domestic relations area, the recognition of a stay-at-home spouse and the value of that spouse to the marital relationship, and to give that value rather than say whatever services or work you did meant nothing. It was all on what the breadwinner provided. I think we've seen a lot more sensitivity in the area of juvenile law that has developed with neglected and abused children and handling of those cases, and what the law states, the presumptions that are present and so forth in that area. There have been a number of areas of the law that I think have now more recognition of women in society.
And as you are wrapping up, are you intending, wrapping up your term as Chief Justice, are you intending to stay on the bench? I
am. My term runs through 2022. I enjoy what I do. I feel very privileged to do it. And I'm excited about the work that I do. I feel very challenged to do it. I enjoy interacting with the people that I do. And so as long as I feel that way, I'm going to keep right on going.
Well, Justice Rita Garman, we appreciate you taking the time to be with us.
Thank you so much.
Congratulations on your completion of
your
term as Chief Justice.
As you said, it's been a fast 3 years.
Thank you.
Thank you.